All right, welcome everyone to the High Society, where the HI stands for Happy Insured. I am your hostess, New Money, about to be Old Money Nicole, and we're excited to have you here today on March the 1st. So, welcome. So, before we get started today, because we have a lot to cover for our small businesses out there, also for our independent contractors out there, this is definitely one podcast you do not want to miss. So, definitely like, subscribe, share the channel with your other friends and your other on your other, looks like it just stopped sharing on me there. So let me go ahead and re-share this. Give me one moment. I've been having issues with my uh podcast tonight. So that's okay. We're not gonna let it stop us. We're just gonna go ahead and get everything reshared. Okay. So give me one moment. Let me just make sure everything is sharing correctly. And then we'll get started again. There we go. Perfect, perfect. So we're just going to keep it moving. So yeah, so tonight we are going to start, we're going to discuss the new labor classifications by the FLSA, the the Fair Labor Standards Act. Okay, so this is something that you definitely don't want to miss. But since we are in the month of March and we have so much happening, I definitely want to keep everybody abreast with all the dates. So today is March 1st. And so today, President Biden did sign the short-term funding bill to avert a government shutdown. Now, when they say that, it makes it sound like, we have averted a shutdown for the next 30 days. That's just not true. We actually just averted a shutdown for 1 week. So we do have until March the 8th, as you can see here, to get 6 out of the 12 spending bills completely passed. Okay. And then, as you can see here, it says March the 22nd is when the deadline is for the remaining 6 out of the 12 spending bills. So, again, the first deadline was today, March the 1st, which, of course, he did go ahead and extend this bill here so we wouldn't have a government shutdown. The next one that we need to keep watch on is March the 8th, get 6 out of 12 of those bills passed. And then the remaining bills will be passed on March the 22nd. So why am I talking about this? I just want everyone to be aware of what we have on our calendar for the month of March, because it is going to be a very busy and important month. I would say one of the most important months out of 2024. So the next thing we're going to talk about is the employee, contractor, and labor laws. Why are we talking about this? Because we actually have a new law that's going to be in effect. It's going on effect March 11th. So again, keep up with these dates, everybody. Maybe you want to get your calendar out, or if you do Google Calendar, just write it down, okay? But the U.S. Department of Labor issued a final rule that will force some companies to treat some workers as employees rather than less expensive independent contractors. This is huge if you are a small business or even a mid-sized business, right? Especially in this type of economic environment. Biden administration issues rule that could curb gig work contracting. Now, I'll have to say, I personally believe that gig work has definitely been propping up our country far as our employment numbers. They definitely have been helping individuals be able to keep food on their table, keep clothes on their back, keep their roof, over their head, keep the mortgage paid. And so now this potentially could actually be catastrophic to our gig economy. So let's go ahead and listen to what is on Reuters, because this is very important. And so we'll take a listen to that now.
Administration on Tuesday issued a new rule that makes it harder for companies to treat gig workers as independent contractors, forcing businesses to offer salary benefits and protections that full-time employees receive. The move has riled some companies who rely heavily on gig workers, such as Uber, Lyft, and DoorDash, whose costs could increase by as much as 30%, and therefore legal challenges are expected. The new rule from the Labor Department overturns one put in place under former President Donald Trump's administration, which made it easier to classify workers as independent contractors. Workers will now be considered employees rather than contractors when they are economically dependent on a company. Business groups and Republican lawmakers say that will cause millions of workers to lose job opportunities and create confusion that could lead to costly litigation. But worker advocates and some Democratic leaders say the rule is necessary to ensure basic worker protections. The new rule is set to take effect March 11th.
So again, this is very huge. As you have already seen, we've had plenty of layoffs already throughout the last few years, and they have just been ramping up and will continue to ramp up. I'm talking about in the millions. You just heard her say in the millions just due to this labor law. But then also on the flip side of that, we have millions losing their jobs to AI. Okay. We have millions losing their jobs to just rising costs that are happening in the business sector. So this is not going to help our gig economy. It's not going to help people who are using 2 and 3 gigs to be able to make a great salary to be able to take care of their lives. Now, on the flip side of that, small business, you need to pay attention to this. It's very important to you because, again, you can actually get in trouble with the government if they deem that some of your independent contractors actually now under this new rule classify as employees. So I want us to go to actually to the U.S. Department of Labor. So when I hear these things, I'm like, okay, let's just go to the straight to the horse's mouth here, okay? So I'm going to leave all these links in the chat because we just can't cover everything today. It's very extensive. I will say that they did a great job on this website answering all types of questions. So they do have here, which I kind of skipped to it already, as you can see, is White House government contracts and then compliance assistance. And then I just went ahead and skipped to the small entity compliance guide because, I wanted to know what the answers are to some of these questions that I'm sure small business mom and pops are going to have. So one thing I will have to just say off the back is that this particular new law is not going to answer all your questions when it comes to if your independent contractors are or are not classified as employees or independent contractors. Why am I saying that? Because it's just not cut and dry. It's not black and white. Everything is gray area. Okay. It's not like how it used to be. So under the previous administration, it definitely was for more small business. So they it was just easier to be classified as an independent contractor. Now, right now, it's like you're going to have to definitely lean to the courts, which means litigation, in order for them to decide if in fact your workers are considered independent contractors or employees. So let's look at this. They actually have the 6 factors of the economic reality test. It's just so interesting to me that they call it that. Let me scroll down to that so you can see this. The 6 factors of the economic reality test. I hope you're paying attention to these words, everybody. This is something new. They never have called this test like this ever. This lets you know that they're probably in the future going to have something called the economic virtual reality test. Why am I saying that? Because even Mark Zuckerberg of Facebook back in 2020 stated that he wants everyone to do everything in a metaverse. He wants us to, work, live, and play basically in the metaverse. So they are definitely in the near future going to have jobs. I'm talking about regular corporations, blue chip corporations that are going to start doing everything in the metaverse. And they may actually have another standard. Maybe they'll call it the 6 factors of the economic virtual reality test. I want you to just start to put your mind in the future, okay? So that way you can be proactive instead of reactive. But let's take it back a notch into 2024, okay? So right now it's just the economic reality test. And so I'm not going to go through all 6 factors, but they, like I said, they did do a good job of trying to explain what each factor means and then give you an example of what would constitute an employee or could possibly, I have to say possibly, doesn't mean it's a fact, or possibly constitute what it would be for independent contractors. So all of these are really great examples. One here that I thought was very interesting is factor number 3, the degree of permanence of the work relationship. Okay, so this one right here is really good. And I want you to I want to read these examples really quickly to you because I don't want to hold you too long, but this is just something that I just know is going to affect a lot of people in the gig economy. So, example number 1, a cook has prepared meals for an entertainment venue continuously for several years. The cook prepares meals as decided by the venue, depending on the size and specifics of the event. The cook only prepares food for the entertainment venue, which has regularly scheduled events each week. The relationship between the cook and the venue is categorized by a high degree of permanence and exclusivity, as the cook does not cook for other venues. These facts indicate employee status under the permanence factor. That could very well include that, because we do see restaurants where they have their own cooks. That's fine. However, for people who have ever hosted events at any type of entertainment venue, whether it's for a wedding or for a birthday or for anything, they usually have a select list of vendors that you can decide from. They're really hard on you bringing your own outside food or selecting your own vendor company you want. But let's just say that this was a huge entertainment group. And what if that one of those vendors on that list, maybe they didn't want to work with any other companies? Maybe this particular one company was enough to be able to pay all their bills, take care of everything that they need for their family. They just exclusively wanted to work with them. Well, in years past, that would have been not a problem. They still could have been constituted as an independent contractor and everything would have been good. But now, under this new law, guess what? It says that these facts indicate employee status under the permanence factor. So now these entertainment venues may have to reclassify some of these vendors potentially, because not every vendor is going to have 1,000 people working for them. Sometimes these vendors may just have one or two people. It may be a mom and pop company, right? May constitute them being employee status now. Example number 2. A cook has prepared specialty meals intermittently for an entertainment venue over the past 3 years for certain events. The cook markets their meal preparation services to multiple venues and private individuals and turns down work from the entertainment venue for any reason, including because the cook is too busy with other meal preparation jobs. The cook has sporadic or project based non-exclusive relationship with the entertainment venue. These facts indicate independent contractor status under the permanence factor. And true, if you are a person and you do have multiple clients, yes, and you're doing all the marketing, you're doing everything, yes, then okay, that's definitely independent contractor. But I guess my concern is what if you just wanted that one client? Again, to me, it seems like too much control over business. Who's to tell you how many clients you're supposed to have? What if you just land that one big contract and you're fine with that? So now you have to be an employee instead of an independent contractor. So why I'm bringing this up is because you need to look at this, whether you are on a business side and you outsource a lot of different areas in your company to maybe individuals, okay? Because sometimes people do. They may hire an accountant. They may hire people to come clean for them. They may outsource carriers or whatever. So you need to look at each one of those now in compliance with this law to make sure that you are compliant. And so I'm not going to read all of this again. I will drop these links in the chat. But this is really great stuff here. And before I get to this one video that I'm going to close it out with today, I just want you to know that here at Legal Shield, we can assist you with consultation. If you have questions where you need advice about this new tax law, about this new law, this labor laws that are here now. And when I talk about here, I'm talking about less than 14 days, guys. I'm talking about less like in 10 days. This is less than 2 weeks. We're March 11th. This is coming nationwide. Okay. So you want to make sure that you speak to a labor attorney to make sure your business is aligned with what's happening right now. We do have 3 packages for you, our Essentials, Plus, and Pro. So definitely make sure you check it out. It's at nivory.wearelegalshield.com/SMB because we care about our small businesses here in America. I know that sometimes it seems like people don't care about our small businesses. They want to run them out of here. But we know that small businesses are the lifeline. They are what keeps everything going here in America. They hire the most Americans out of everyone, out of mid-size and even large corporations. It's our mom and pop. So we're here to support you. If you have any questions, my contact information is there. You can always message me. You can also send me an email to contact@empirenourse.com. I'm here to help you. Also, I want to talk really quickly to our ride share deliverers out there, okay? As you can see, this could potentially affect you in a very major way. I mean, just think about it. If these companies are all of a sudden have to reclassify workers to employees instead of independent contractors, I'm sorry to say, but you are out of here. Okay. And they may keep some. Okay. They may not be able to keep all out 100%. They may be able to keep 20% or whatever their budget is. Right. So hopefully you would be the person that they keep. But if not, you need to start thinking of other plans, other things that you can do. We would love to have you on board with Legal Shield. Come on board as a legal associate. Why don't you help us help other ride shares get the information out to them, get them protected? As a rideshare delivery driver, everything is important. Every dollar is important. When you drive for a living, the chances of receiving a ticket goes up exponentially. Paying fine cuts into your income, and points on your driving record can disqualify you from working for popular rideshare and delivery services. So I'm telling the competition is going to get even more stiff. They're going to be looking at that, right? Even more so than they do now. And so you want to be able to get this $14.95 a supplement that comes, of course, in conjunction with your $29.95 legal plan. So that way you can have unlimited calls and consultation with our attorneys, document review to protect you. It has so many more items here that can help. We can help you with your moving violations, you name it, we can help you with it. Okay. So start thinking about this now, you guys. Get in front of this. This is why I'm bringing this to you today. I know it's March 1st. We have 10 days left before this goes into effect. So you want to make sure, that you know how you're properly classified. If you can still be classified as an independent contractor, and you can speak with your company and make sure that they can keep you on board, in advance. Also, you also know in advance if you are not going to be still listed there, or if you're not going to be kept with that company, because now they have to classify people's employees and they may not be able to keep you. Now you have 10 days to be able to figure out what you're trying to do. Okay. Or if you have questions, or if your company has questions, this is when you really need to go ahead and get this legal plan so you can ask those attorneys so they can help you with that. And again, I'm here to help you. And I'm going to close it out now with this video here because it's really great for business insurance. I love them. I get all of their communications. And so we'll see you on the next podcast.
Hello and welcome to the BI interview. I'm Gavin Suter. I'm the editor of Business Insurance. I'm here today with Chris Parlow, who is a partner at Morgan Lewis, and he's based in New York. Hello, Chris.
Hello, Gavin. How are you?
I'm great. Thanks very much for joining us today. So we wanted to talk about the final rule on independent contractor classification under the Fair Labor Standards Act that the Department of Labor has just published. And it has some, I think it's been awaited, and people wanted to see exactly what it was going to say. And it obviously has implications for employers. So maybe we can just start with that. What are the highlights of the new rule that employers should be aware of?
I think the first thing is we were waiting for a long time, but there weren't that many changes from the proposed rule that came out some time ago. So to the extent people analyzed the rule at that time, the changes that we observed are more specific to certain industries than they are to the general population. The big change, of course, is that the rule went from two main factors or core factors and expanded that to 6 factors. And the final rule has de-emphasized the importance of control, which in what I do for a living, control was easier to meet as a test than what I think remains still a somewhat amorphous economic reality test. So that's an important piece. The rule also, again, didn't go into specifics regarding any industry. One problem I have, and I'm not trying to be a hater about what the Department of Labor has done, but in deciding to be general in nature, it really doesn't address what I think is the bulk of the current economy, which are many people working from home, many people choosing to work remotely, and that's a different dynamic from the case law and the tests that was developed in the 1940s and 1950s, the Department of Labor has tried to move forward. And so what they did instead is open the door for individuals to seek sub-regulatory guidance. And I will admit I had to look up what that meant, even though I do a lot of this. And what that goes to is, can we get opinion letters? Can you get other non-formal guidance from the Department of Labor that might be particular to your individual business? And while that sounds good, over the last 8 years, we've seen the Department of Labor move away from doing that. So I hope what this signals is a greater receptivity to companies in a specific industry to ask, hey, how does this aspect of the rule apply to my particular circumstance? So those are some of the big changes. I think the audience also needs to understand this is just an FLSA test, as you mentioned. It doesn't apply to the test under the IRS or the test under the anti-discrimination laws. And so companies have to remain vigilant to how their circumstances play out under all of those additional tests, including some states that have some pretty draconian requirements for independent contractor.
Maybe you can talk a little bit about the economic realities part of it. Can you maybe explain that? How's that work?
Sure. And again, I think the Department of Labor tried to do what it could. In their mind, the difference is whether an individual is in business for themselves or they are really providing a benefit for the company. And economic reality has been part of a form of the test for a long time. And it does look to whether the individual, through the operation of his or her business, can recognize, a profit or loss, or are they so wed to what the company is dictating they can charge for something, the expenses that relate to the business, that really there's little control that the individual has over the economic realities of the situation.
Right. And just with the explosion in the gig economy over the past few years, one imagines that this is it's a particular concern for a lot of employers now.
It is, and I think the realities of the gig economy world are not particularly addressed here. There are examples that the Department of Labor has put in the rule, but I didn't see the one that said Mary or Bob has chosen to work at home, 500 miles from any company location. They've chosen, because it works for them, to do the bulk of their work for a year or 2 or 3 for one particular company, and they're very fine with what that company has chosen to pay them. They could work for others, but this is working out pretty well, and I'm happy with the amount I'm being paid, and I get to work nights or weekends or vacations or not work, and I choose my hours and I choose how much time to put in. To me, that's an independent contractor, and that still could go either way under the new test, depending on how a court or agency applies it.
So what do employers need to offer workers that fall under the employee category under this rule?
Sure, and Gavin, I'm interpreting that as if a company believes that it may have a misclassification situation and wants to remedy that. And the first thing I would say is, before you get there, the rule and the publicity regarding the rule will likely generate questions from your workers. And for those individuals who are in a gray area, it could go either way. I think it's important for companies to be ready to answer those questions. So having a set of Q&A ready when a manager is asked, hey, I saw this new rule, what does that mean for me? Should I still be classified as an independent contractor or an employee? Or more pointedly, hey, I don't think I'm an independent contractor. I want what the people who are deemed employees get. And so being ready for those questions, I think, is really important, as is doing an audit of the positions that you think might fall in a gray area. If you've determined as a company that someone might be misclassified, or that you are going to do a reclassification, it's important to message that such that it doesn't give rise to individuals running to lawyers and saying, hey, look what just happened. I must have been previously wrongly classified. But if once you get to the point of deciding, hey, I've got to make a switch here, an important piece is the employee benefits component, which can have a real cost to it. Do they now need to be in a pension plan? Do they now need to be in a health insurance plan? The plans that you and I typically see as ERISA type plans. But aside from the formal plans that exist, all of the little subsidiary benefits, the fringe benefits, are they now entitled to vacation? Do they get a bonus? Do they get all of the things that employees would get? States are going to come looking to you for workers' compensation premiums, unemployment, disability. You've got to put in place a system for now doing withholding. Companies may have been doing partial withholding depending on the independent contractor status, or no withholding at all. And now they're going to have to be collecting and remitting those taxes to the government. Training that wouldn't otherwise have been applicable to independent contractors. And you think of the sexual harassment training that's now mandated in many states, that's got to be rolled out to these individuals. What policies and procedures did you not have them following in the past that you now want them to be aware of? Confidentiality, protection of trade secrets, cybersecurity. Now having to do the immigration checks themselves, which may not have been done or may have been done by a staffing agency. And then I say little things, but meal and rest breaks, seating laws, all of the things that you wouldn't have otherwise applied. And with some of the difficulty being, if these individuals continue to work from home, how are you making sure they take a break to eat a meal? Where are they sitting? When are they starting and stopping work? What are you doing to monitor it, to monitor the start and stop times, and all the things that would typically be done for an employee population? So it's a lot.
Right, it does sound like a pretty extensive list there. What about managing the potential liabilities that they may face?
So when we look at the risks posed in situations like this, I put them in two buckets. What is the risk of you actually being found to have gotten this wrong, right? And taking all of the prongs of the test and analyzing where do we fall on each one of those factors. It becomes a little more difficult because the Department of Labor has said, in addition to the 6 factors, additional factors can be considered. So one of the things I was doing today is for one industry, I put together a list of 30 things that the courts have focused on in determining independent contractor or employee within that industry. So that's well beyond the 6 that the Department of Labor has identified. And you want to tick off all of those things. That's just to determine whether you've made a proper determination about classification. The other bucket I use is, let's say you get it wrong. What are the damages, and how can you mitigate those so that if you are found to have gotten this wrong, there's not a huge liability or exposure as a result. And that goes to what I just mentioned. Analyze what are the costs of putting 10 or 20 or 100 individuals into your plans and taking care of all of the other things we've mentioned. It's important for lawyers and HR personnel to make the business line leaders aware of what the potential exposure should be, and that should be something that's considered in determining what to do now in light of the new rule.
Okay. Excellent. Well, thanks very much for joining us today, Chris. That was a really great overview. Thanks very much.
You're welcome, Gavin. Very nice seeing you.